and listen in. This is Judge Tony Graf presiding at the 4th District Court. Let's listen in.
Order the incarceration in the county jail for up to 30 days or both. Any alleged violations will be carefully evaluated, and the court will impose only those sanctions that are appropriate and proportional under the circumstances. Before imposing any sanction, the court will make specific findings on the record. In addition, the court may consider any remedial measures, including immediate suspension of video transmission for the hearing in which the violation occurs, with proceedings continuing on an audio-only basis, and disqualification, if necessary and narrowly tailored, of the news organization that filed the request in order for electronic media coverage of the court proceedings for that hearing from serving as pool camera operator in this matter, where such a measure is required to ensure compliance with the standing decorum order and protect the rights of the parties. Any such remedial measure would be considered only as a last resort and only to the extent necessary to address the specific violations at issue. Counsel will have an opportunity to provide input before the court makes any final determinations regarding sanctions. The court values that input and will give it careful consideration. I want to be clear that these measures are intended to preserve open and transparent courts while ensuring fairness to all parties, and the court remains fully committed to the presumption of open proceedings under the applicable rules. Rather, these measures exist to protect the constitutional rights of all parties while preserving the integrity, fairness, and orderly conduct of these proceedings. With respect to media coverage in the courtroom, the court offers the following additional guidance to assist everyone in navigating today's proceedings. The pool camera has been relocated to the rear of the courtroom. The camera operator shall not zoom in on any individual seated at counsel table. When counsel tables are filmed, the camera must remain in a wide shot that includes all individuals seated at the table. Attorneys and witnesses may be filmed individually when standing at the lectern or seated in the witness box. I would also ask counsel to be mindful that microphones are located throughout the courtroom and may pick up conversations. Counsel may wish to consider using screen protectors on laptops and taking reasonable steps, such as covering one's mouth when speaking, to avoid the inadvertent capture of private communications, whether by camera, microphone, or those present in the courtroom. Third, the court wishes to address the camera operator. At this time, Mr. Josh Demick, could you come forward to the lectern? Could you please state your name and spell it for the record?
Yes, my name is Josh Demick, Josh-Demick.
Thank you. My intention is not to cause you any embarrassment or discomfort, although it's probably not feeling that way on your end. I simply want to ensure that the expectations for today's proceedings are clear. During today's hearing, what is your primary role?
My role is to cover the hearing that we have going on this afternoon, and I have read over the decorum and the EMC as well. My plan is to solely focus on the individuals that will be speaking up here.
All right, you anticipated my next question, which was, have you read the December 23rd, 2025 standing decorum order, which you have, and I appreciate. And do you understand the guidelines as they relate to your responsibilities today, including the additional guidance regarding camera position at counsel table and the filming of attorneys and witnesses that I just put on the record that was not in the decorum order?
Yes, Your Honor.
All right. Do you need any additional time to review the order or to reposition the camera to ensure full compliance?
No, Your Honor.
All right. Do you anticipate any difficulty complying with the order or today's guidance?
No.
All right. Thank you, Mr. Demick.
Thank you.
Before I let you go, as I just asked questions of the pool camera operator, Mr. Dimmick, I'll turn to counsel. Do you wish to weigh in on what the court has just done?
No, Your Honor, thank you.
Thank you.
Yes, thank you, Your Honor. Richard Novak for Mr. Robinson. May I speak from here?
Yes, Mr. Novak.
All right, thank you, Your Honor. We appreciate that the court, on its own accord, moved the videographer. I don't know where the still photographer is, but we continue to be concerned that any video images of Mr. Robinson during court proceedings, close-up images of Mr. Robinson during court proceedings, interfere with his right to a fair trial. I think I heard everything the court said about the videographer, but the still photographer is still seated in the same place where they were last week, and we would ask the court to order the still photographer not to take any photographs of Mr. Robinson's face or person during the hearing, in the same way that the videographer has now been ordered to be focused on the court, the witness, if somebody's testifying, counsel at the lectern, or generally the people seated at counsel, what the court referred to as counsel table. We do not want to see still images again of Mr. Robinson's face in the media with more speculation about meaning of his facial expressions or the lack thereof. And so we really appreciate what the court did on its own, sua sponte, I guess we would say. But we have the same concerns about the still photographer.
All right, and before I address that, any questions as it relates to Mr. Dimmick? I want to excuse him to go back. Standing in front of the court is no fun. I recognize that.
I was just trying to keep him up there as long as possible.
I see. Yeah. All right, Mr. Dimmick, thank you so much.
Thank you very much.
All right, before I address that, I'll allow the parties to be heard before I address what Mr. Novak has brought up as it relates to the still photographer. To the state.
Your Honor, I think Your Honor is appropriately concerned about the video, any close-ups of Mr. Robinson. I'm not sure that a still camera presents the same concern. This is a public hearing, and I think that that it's appropriate that still photography be taken. I don't know that it raises the same concerns that Your Honor's raised with the video.
Thank you. Any other party wish to be heard?
I'll be brief, Your Honor. Michael Judd on behalf of the news media. We agree that with what the state has just said. The concerns that I understand the court trying to address involve the capture of moving lips that can be used by lip readers. We have dealt in the past with inadvertent overhearing of actual conversations. I don't think still cameras present that same issue. The idea that a participant in a public hearing, including the defendant, cannot have their image captured by a still camera because a facial expression is somehow too much to let the public see, simply don't agree with. It is, of course, the court's prerogative to set the guidelines that it believes are appropriate to balance these interests, but it will come of no surprise to the court that the news media believes that that particular measure of saying even a photograph of a defendant in a public courtroom is too much to allow without threatening fair trial rights in a way that goes beyond that balance. We think that's too far.
All right. Mr. Novak, I do have a question for you. Has there been a violation of the decorum order by the still photographer in any of these proceedings?
I am not aware of violations by the still photographer, but I am very aware, if I may, of what we believe is unfairly prejudicial media content based on the images. And video images, yes, can be embedded in electronic media, but still photographs also are still appearing, still photographs from the courtroom are still appearing in print media and in less, well, you know, what we've referred to as less formal media channels. So we are still very concerned, and I don't understand why there would be any even marginal negative access to the public to this hearing by the still photographer being in the back of the courtroom and taking photographs of the court, meaning Your Honor, of witnesses on the witness stand, if that's what the court's going to permit, of counsel. I don't have a problem with that. But we continue to have grave concerns of huge photographic lenses being focused on our client. And the results of that, and I'll just make a representation to the court that while we were in court last time, Mr. Burt and I both received, literally in real time, long ranting voicemails from people who were watching the proceedings. Now that was on video. I received another one of those calls today referring to my client's facial expressions from somebody who decided to leave a long, aggressive message on my office phone. And I'm very concerned that even still images of Mr. Robinson's visage in the courtroom are going to interfere with his right to a fair trial. And we've reached the point, because of the prior violations that have occurred and because of the nature of the media coverage, where Mr. Robinson feels like he may have to make a choice between two of his Sixth Amendment rights. And that's the right to a fair trial and the right to be present. And we want him to be able to have both of those rights, and the way, and all of his rights. And the way he can exercise both his right to be present and his right to a fair trial is for the court to move the camera to where the video camera was ordered to be.
Thank you, Mr. Novak. Thank you to all parties. I appreciate your input. This is an important matter, and the court takes it very seriously. I note that there has been no violations of the December 23rd, 2025 decorum order by the still photographer. That being said, this court wishes to exercise caution and will request that the still photographer go behind the bar, to the bar being the separating lower wall, and reposition his camera at that place. I appreciate the patience of all parties as we do this. And again, this court is balancing open and transparent courts with the constitutional rights of all parties involved. All right, while that's occurring, I'll turn to the state. The court would appreciate a brief update on the status of discovery.
Your Honor, Chad Grunender for the state. To date, we have shared with the defense 100% of what we have received from law enforcement. With that said, we have been informed late last week that there is approximately, well, there are several terabytes of digital evidence from phones and other digital devices that the State Bureau of Investigations has in their possession. We are collecting a 20 terabyte hard drive to two of them, one for us and one for the defense. We did receive a letter, I think, this morning from the defense outlining their expectations with respect to how that would be received, original form, and more specifics as well. So we're in the process of coordinating that download onto those hard drives of the digital evidence that's been collected, and we will provide that as soon as we receive that and downloaded to the defense. We are still working with law enforcement on the download of approximately 30 days of all of the surveillance video at UVU. We were told it was approximately 300 terabytes, and that's being downloaded 24/7. So that is still in process. So we're actively working on that. and looking forward to collecting that and passing that along to the defense. It will need to be shared in some sort of similar fashion, I'm sure, with respect to hard drives.
Thank you, Mr. Grunander. Does defense want to be heard?
That is correct, Your Honor. Stacey Visser on behalf of the defense. We are in communication with the state about what we believe is missing at this point, and we are anticipating a large amount of digital discovery in the next few weeks that we will need to process.
All right. Thank you.
May I supplement this conversation, Your Honor?
Briefly.
Thank you, Your Honor. We've kind of divided up discovery responsibilities, and mine is to address what I'll call non-digital forensics. So there are many items of seized evidence that have been sent to various law enforcement labs around the country without getting into the details. We have some very, what I'll refer to as summary reports of those evaluations. But as the state attorneys know, we're going to need all of the underlying data, notes. These relate to things like DNA and other forensics. So if we haven't provided them with a very, very detailed list of the types of documents we need, we will. But I think Mr. Grunander could speak to this in more detail in terms of the status of that. But I think that's another big chunk of materials that presumably the state attorney's office has not received yet from law enforcement. And so obviously they haven't had a chance to give it to us, and we haven't had an opportunity to look at it or to have our own experts review those types of materials.
Thank you, Mr. Novak. All right, before the, Mr. Grunander.
We'll make a point to follow up on that with the law enforcement agencies. We'll communicate with defense counsel on that, Judge.
I appreciate the cooperation between the parties. Before the court proceeds further, it's appropriate to address the record. The court notes the recent filing by victim representative Erica Kirk involving the statutory right to a speedy disposition of the charges under Utah Code Section 77-38-7 sub 2. This court raises this issue solely to ensure that the record accurately reflects the statutory obligations governing the matters presently before it, and not to suggest any view regarding the merits or outcome of these proceedings. Under the statute, a crime victim has a right to a speedy disposition of charges free from unwarranted delay. When considering a defendant's request to continue a previously scheduled trial or other significant criminal proceeding, the court must inquire into the circumstances asserted as the basis for delay and must consider the victim's interests in timely resolution together with the defendant's constitutional and statutory rights. The court emphasizes that the defendant's rights to due process, to present evidence, and to receive full and impartial consideration of all arguments remain paramount and undiminished. The court's responsibility to balance these interests faithfully and without preference to any party. As previously stated on the record at the September 29th hearing, justice demands that both of these principles, the rights of the accused and the rights of the victims, be honored without compromise. With that framework established, the court will hear briefly from counsel concerning how you propose proceeding today.
Thank you, Your Honor. Richard Novak, again from Mr. Robinson. We're prepared to continue with Mr. Gray's testimony. We did file what I captioned a renewed request that this court proceed under a particular section of the Utah Code to refer this motion to the Attorney General. So it's obviously up to Your Honor to decide if the court wants to address that renewed request in writing now or at a different time. I do want, whenever it is court's view that it's timely, to address the issue that the court just brought up, which is how the court, well, what I want to address is how the court will manage the question of whether Mr. Robinson needs more time to prepare for the preliminary hearing. So the court got an update on the status of discovery. The court noted Ms. Kirk's filing, which of course we are all aware of, and we understand her rights as the representative of the victim in this case. There are challenges under Utah law when the defense needs to communicate to the court the details of its diligence in terms of preparation for a hearing, because we're not going to make a public filing of work product. And I'm sure the court understands exactly what I mean.
Yes.
So what I'm saying is the court brought up the filing and the significance of that for future proceedings. We're going to need to have, if I may, what I would call sort of a case management conference at some point about how the court will manage our need to be able to share with the court the status of our work, which we believe is confidential and privileged, in light of the fact that every time we file something and ask the court to designate it as private, we have counsel for the media trying to unseal it. And we also don't intend to disclose to the state the status of our diligence. And so I'm not asking the court to address it now. I guess I'm just trying to put a Post-it note on somebody's list. It's certainly on our list, and we didn't really intend to bring that up at the outset of today's proceeding, but since the court mentioned Ms. Kirk's filing, it just seems like the right time to mention that. So we're prepared to proceed with further testimony from Mr. Gray and keep going with the evidentiary hearing unless the court wants to address what I captioned our renewed request.
Thank you, Mr. Novak.
Thank you.
To the state.
And Your Honor, the state's prepared to go forward with the evidentiary hearing. We are prepared also to address this renewed request. If Your Honor would like to do that at the outset, I would suggest that Your Honor set a time limit on that argument so that if, assuming that motion's denied, that we can move on with the evidentiary hearing. We've got witnesses who've been subpoenaed. They're ready to testify.
All right. Well, I appreciate that update, and I do want to give some guidance of how today's hearing is going to go, and both parties have touched upon that. Based on the record before the court as it relates to the evidentiary hearing, and in order to ensure a fair, orderly, and efficient proceeding, the court will proceed as follows. First, we will address what Mr. Novak just brought up in regards to the referral to the Attorney General's office briefly, and you'll see why I say briefly with my next statement. Counsel will have until 4:30 to present evidence, including cross-examination and any redirect. Motions for supplemental briefing are denied at this time, as the court finds the issues adequately framed for today's proceedings. These parameters are not intended to limit any party's substantive rights, but to keep the proceedings focused and free from any unnecessary delay. Upon the close of the evidence, the court will proceed to argument. Each side will be allotted 15 minutes. Mr. Novak, or to any of the attorneys who would be making closing arguments, if you intend to reserve time for rebuttal, please allocate your time accordingly. This court will conclude at 5 o'clock. And in addition, the court anticipates issuing its ruling via WebEx in order to give the evidence and the arguments presented today the careful and deliberate consideration they warrant. That proceeding will be scheduled at the conclusion of today's hearing. And so, counsel, with that in mind, we will turn to the motion to refer, or the motion concerning the Attorney General's office. I will hear from both parties. It is your time. I am not putting constraints on who you call, what questions you ask, in part, but keep in mind these time constraints as we address this issue. Mr. Novak.
Thank you, Your Honor. We filed what we captioned the renewed request, because obviously at the last hearing, we brought the request verbally. And obviously the court's read our renewed request and our points and authorities, we received the brief written by Mr. Ballard, which is very clear and very well written, and we understood the views expressed there. We just disagree fundamentally on what that code section means. We disagree fundamentally on the suggestion that there's a separation of powers problem. It is ultimately this court's responsibility to ensure that parties are represented by conflict-free counsel. Obviously, in the legal profession, there is an initial expectation that counsel will avoid conflicts. But there are always situations where a party needs to bring a conflict on the other side to the court's attention, and the court has both the statutory authority and the inherent authority under the common law to do something about it. So we do believe that this is well within the court's discretion. The statute actually tells the court that it needs to encourage the state to seek assistance. That seems to be a gentle way to say that the state is at least disqualified from litigating its own disqualification issue. And then I'm going to reserve the rest of my time for our evidentiary hearing and closing arguments.
Thank you, Mr. Novak.
Thank you.
Turning to the state, Mr. Ballard.
Your Honor, it feels like Groundhog Day. Here we are, we've got, again, we're supposed to be having an evidentiary hearing, and Mr. Gray should be on the stand, and instead we're arguing again this issue about whether this court can refer this issue to the Attorney General's office. And I guess if I were in Your Honor's position, I'd be wondering why the defense insists on raising this issue in a way that doesn't allow this court or the parties to be able to fully analyze it and brief it. The defense finally did file a written motion, but waited until Friday afternoon to file that. So as we've outlined in our alternative point in our response, I think this court would be well within its discretion to just deny that motion as untimely. But on the merits of that motion, I think, as we've explained in our response, and Your Honor's indicated that you've read that, I think we've explained clearly why this statute does not apply in the way that the defense claims it does. And I'm happy to walk through the statute and the points that we've made. I don't want to belabor that. If Your Honor has any questions about the statute, I'm happy to answer those. But I think it's clear that this statute does not allow the court to replace a prosecutor. At best, what it allows is the court to recommend that the county attorney seek the help of the Attorney General's office. So I don't believe that this statute has any application. The cases that the defense has cited are irrelevant to this issue. And for those reasons, unless the court has any further questions about the state's opposition, I'd submit it.
Thank you, Mr. Ballard. Anything further from the parties before this court issues a ruling?
No, thank you.
All right. So before this court is the defendant's renewed request to refer the pending motion to disqualify to the Office of the Utah Attorney General. In support of that request, the defendant relies upon Utah Code Section 17-18A-304, which provides that the Attorney General shall assist a county prosecutor only if the court finds that the prosecutor is unable to satisfactorily and adequately perform the duties of prosecution, and recommends that the prosecutor seek additional legal assistance. The defendant argues that where there exists a non-frivolous basis, factual basis, suggesting a potential conflict of interest, the court should make such a finding and recommend assistance from the Attorney General. The court has carefully considered that argument and reviewed the briefings. However, the statute does not adopt the standard proposed by the defendant, nor does such a standard appear in existing case law or court rules. The statute requires specific findings regarding the prosecutor's inability to satisfactorily and adequately perform prosecutorial duties before referral is appropriate. At this stage of the proceeding, The court is not persuaded by those statutory conditions have been met. Based on the record presently before the court, there is no indication that the Utah County Attorney's Office lacks the resources, knowledge, or ability to litigate the motion to disqualify on behalf of the state. Accordingly, the court cannot make findings required under Section 17-18A-304 to justify referral to the Attorney General's office. For these reasons, and without expressing any views on ultimate merits of the motion to disqualify itself, the defendant's renewed request for referral is respectfully denied. All right, counsel, let's go ahead and proceed. Mr. Ballard.
Thank you, Your Honor. Could I just clean up one piece of the record? Your Honor referred to the statute as 1718A, but I think it's actually been renumbered. It's 17-68-304 is the current citation.
Agreed.
Thank you. I appreciate that correction, and that is correct. I appreciate that, and to clarify the record, thank you to both parties. And so my ruling reflects that 17-68A-304. All right, counsel, are we ready to proceed with continuation of the direct examination of Mr. Gray?
Yes, except to quickly implement the exclusionary order that the court entered at the last hearing with respect to prospective witnesses.
All right, the court will take a very brief 3-minute break in order to accomplish all parties speaking with whoever needs to be spoken to and for them to be excluded, and then we'll proceed. It is now 1:38. We'll come back at 1:41. Court is in brief recess.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.